Good evening and welcome. Hopefully everybody can hear me, and if you can't, please just note in the chat box. Welcome to the Micklin Law Group's webinar series. Today we are discussing 5 tips for an easier physician divorce. So before we get into it, let me just tell you what to expect. This is scheduled as a 60-minute webinar. It's usually less than that, but I never know how long it'll take me to get through the information. I try not to rush it, but I also want to be sensitive to your time and get through this as fast as possible, but as accurately as we can. It's a one-way communication, so hopefully you can hear me, but I wouldn't be able to hear you if you speak or have any issues. But you should have a chat panel. Usually it appears on the right side of your screen, and on the bottom is a question and a chat section. I usually recommend people post questions as we go, even though I won't address them until the end. I don't like to break up the flow of their information, but I don't want you to forget your questions. So you can put them up there. It doesn't interrupt me. And then I'll take as much time as I need to afterwards to go through with it. And with that, let's jump into it. So for those who have not worked with me, this is me. My name is Brad Micklin. I'm a New Jersey attorney. I'm the founder and managing member of the Micklin Law Group. We are a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters. We have offices in Nutley, Montclair, and Saddlebrook, New Jersey. I do want to apologize in advance. There's some construction going on in my building, so you're going to hear some noise from time to time, maybe some drilling, maybe some conversations. I apologize in advance. You may even hear that now. I hope it doesn't interfere with the audio too much. Here are some awards I've been fortunate to receive, both through client and peer reviews. I don't put them here to impress you, but to impress upon you that I have been doing this for a very long time, over 20-something years. I am confident that I am capable of giving you information to help you through this process, which no matter what type of divorce you would be going in is difficult. You want to make sure that you have a good attorney by your side. Also done a number of court appearances. Here's some snapshots. Fox News, Inside Edition, Larry King when he was with us, obviously may he rest in peace, I-24, and many other national legal commentary positions I've taken in the past and quite possibly in the future, but I haven't done a lot recently with COVID quarantine, but I might get back into that soon. So let's jump right into it. Let's first talk about custody and parenting time. Now, when we say physician divorce, it's not just all about being a doctor and the value and assets, but it's also the life issues that you deal with. And custody and parenting time usually the most significant of issues to deal with in any divorce, but there are unique factors for a physician divorce that I do want to discuss. And if you're watching this and you're not a physician, these tips are still going to help you, but they are geared more towards the lifestyle of the average physician. So let's look at some custody and parenting time issues and how you can best protect yourself. So first is you want to build in some flexibility if you have a demanding career, demanding schedule, unusual or long hours. You want to be able to have some flexibility so that you don't have to worry about losing your time or the difficulties you may have when you constantly have to change your time. Your spouse is probably well aware of your career demands and should be somewhat amenable to building in some flexibility, and it helps for both of you. You want to have some provision in an agreement or a custody order that allows flexibility to change and increase days. You may, depending on how strained your relationship with your spouse is, you may need to have a specific protocol so that you can say, if I notify you, for instance, 48 hours in advance, that you'll accommodate makeup time or change in my schedule. That's going to depend, again, on the nature of your relationship, both when you start your divorce, but also as you're going through it. It may change what was a good relationship may go sour, and you may have had a sour relationship that may actually improve. So you need to judge based on how difficult the scheduling is right now with how much flexibility you need to define inside of your agreement as you go forward long term. And you always want to have provisions about getting makeup parenting time. Assuming you do have a demanding career or schedule, you don't want to lose time just because of that. And you can't always count on your spouse being understanding when things change. Even relationships that may be good right now, I hate to be pessimistic, often change. The dynamics change once you get divorced. Sometimes there's new relationships that get involved on either side of the table that can complicate parenting. Those new relationships can have other children, other relationships that get involved in here. So you want to take the time while things are at its calmest to build in a schedule that will accommodate your needs and the demands that your career may place on you and your children's relationship. Moving on to some additional issues. I usually recommend some kind of extended vacation time. This is obviously not just standard to a physician divorce, but anybody wants to have extended vacation time. You want to have at least a week or two. You want to define if it's consecutive or unconsecutive, how much notice you need to give in advance. What if there's a conflict between you and your spouse's choice for vacation times? Build in as much foreseeability to these issues as you possibly can. Another issue, and this kind of cuts both ways, is something called the right of first refusal. And that is really a real estate term, but we use it in custody. And that's intended to say that if one parent's not going to be with the children or child for a fixed amount of time, it could be anywhere from a couple hours or an overnight, that the other parent will be given the choice of having parenting time with the child as opposed to having the child with a babysitter or another family member. Now, this is a good provision in some cases. In some cases, it's a burden. And that's why I say it cuts both ways. So, for instance, you may want to have the flexibility of using a babysitter because you want to have stability in your schedule and you don't want your spouse making demands on your time with your children. But you or she or the other spouse may want information about who the babysitters are going to be, or believe that a stranger shouldn't be with the children over a natural parent. I generally recommend it, even though, like I said, it can be invasive in some ways and can be complicated at certain times. But I think ultimately it's the best because it's not a requirement. It's an option that you have to give the other parent the option of having parenting time. And if you think you're going to be a person who's going to have to cancel parenting time more often, and that's kind of the underlying theme to this webinar, is that the demands may cause you to have to surrender time or not have enough time, you have to decide whether or not having the other parent's option to take the child during that time, or if you'd rather have a babysitter. There's really no right or wrong answer. It's really going to be what you think is going to be best for you and your child or children. Next thing, again, not just to physicians, but I think more important, I always recommend that you define in your agreement what is a change of circumstances. So custody and parenting time, as well as many other issues in a divorce like child support and alimony, are changed based on a material and substantial change of circumstances. The problem is there aren't many clear definitions of what is and is not a material and substantial change of circumstances. So I normally recommend to all of my clients, but especially my physician clients, to build in what that definition is. When it comes to, is it going to be a certain amount of time? Is it going to be the age of the child or the educational level of the child? Is it going to be a change in the parent's age, work schedule, relationship, residence? Try to foresee, depending on how old your child or children are, how many issues are going to come up in your future that you see impacting the amount of time you may want to spend. You know, if your child's 3, try to think what it's going to be like when the child's 13 or 14, and that's a new schedule. the law doesn't necessarily allow you to change these things simply because of passage of time. So having it defined, even if it is passage of time, you can define that in advance and agree upon that in ways that the court will not recognize. So take what they are and define them so that you have an expectation of when things will be changed, hopefully for your benefit and to improve your relationship in time. And I also recommend you put in a mandatory mediation clause. As you probably know, if you've been involved in any kind of divorce litigation or post-judgment issues, it's time-consuming, it's costly, it's taxing. Mediation is, by the way, also a requirement in New Jersey courts when there is a custody matter, but I generally recommend that you have a broader provision in your settlement that says all issues regarding either your settlement agreement or at least your children will go to mediation before litigation. Like I said, it's faster, it's cheaper, it's easier. I often also include, not necessarily in my agreements, but as a suggestion when these issues arise, when mediation is unsuccessful, I recommend binding arbitration. And for the same reasons, it's a lot faster, it's a lot less expensive, it's almost the exact procedure, but less formal than going to court. And you come out with a final decision that is binding, hence the name. Generally, you'll pick a retired family court judge. So you're getting somebody with the same mindset and experience to render the decision, but it's a streamlined process. It's scheduled much more expeditiously. It's resolved much more expeditiously. And because of that, your issues are resolved more expeditiously and for a lot less money. The negative to binding arbitration is that you're bound by it and you have very little, if any, grounds to appeal or to reconsider these decisions. So you have to balance what you're giving up to what you're getting when making that. But mediation is always a good provision to include. There's never any harm to trying that and expediting the resolution of these issues. Now, another issue often significant in many divorces, but especially in physician, is appraising a medical practice. Now, this can be your own practice. It can be if you have an interest in the practice. It could be if you have the right to later have an ownership interest in your practice. Probably one of the more complicated aspects. Now, this will largely, just before we get into the meat and bones of this, you're going to have professionals that are in charge of this, but understanding the process and the things you need to consider first will help you find the right professionals and make sure the process goes the right way for you. So let's look at some of the issues. First, you want to talk to your attorney early on about a forensic accountant and or evaluator. They may be separate roles. You may need separate people. One, for instance, to evaluate the practice, one to evaluate the lifestyle. But you want to find and interview some people because you want to make sure that you work well together. You want to make sure that your attorney either has some experience with the people you're choosing. You can often go to your attorney for recommendations. We will usually have people we've worked with in the past that we recommend and that we think are well suited. And another issue that you need to consider at the early stage is if you want to get your own or if you want to share one. So there's really three different ways to have an expert appointed or an expert chosen to evaluate a practice or any business interest for that matter. Either you can go to the court, file a motion, ask the court to appoint somebody. You and your other spouse can agree to have a joint expert, or each of you can get your own expert. Now, I generally recommend in almost any evaluation that you start with either a court-appointed expert or a joint expert. The reason is if you have a court-appointed or joint expert and you don't like the finding, you then have the right to get your own. But if you start with your own and you're not happy with that, because look, you can't control the outcome. You can hire somebody on your own, pay them an awful lot of money and get a bad report. That you're bound with that. Now, you don't necessarily always have to turn over a negative report if you chose somebody and they went to somebody else, but you do have to disclose that you obtained it and it will likely then be requested. So that's getting a little further off track. What the point I really want you to take from this is it's always best to start with a court appointed or joint because you reserve the right to get your own after it, with the hopes that you don't have to. If the joint or court comes out favorably to you, not only do you not need to bother with the other one, but you can shed some credibility concerns when the other side chooses to get his or her own after agreeing to a joint. It just shows that they weren't happy and they ran out and got it. So hopefully you're not the one that has to do that. You also want to speak to your staff, let them know what's coming. Find somebody that's in the practice that you trust and work well with. Make that sort of the go-to person for the forensic, because you don't want to be taking off your valuable time that you could be putting into the practice or into your divorce work, which can be very cumbersome, or even to your free time or your parenting time. You don't want to be the one that's getting all the documents, that's responding to all the requests, that's reading all the letters. It's simply too much to deal with, that you want to have somebody who's knowledgeable about your practice that you trust to be the person, that the middleman, to get all this together, communicate, and give everything back. You and your lawyer should be supervising and reviewing all of it, but neither of you should be the ones doing it all. Now, one of the most difficult things about getting a business evaluation done are the documents that are required. I always recommend start as early as you can. If you're fortunate enough to know you're going to be going through a divorce soon, but it has not started, start getting all of your records together, both business and personal, and for at least the period of your marriage. Now, if you're married 20, 30 years, you don't necessarily have to go 30 years back, but if you're married shorter term, 5 or 10, you want to try to go as far back as you can, especially if you have a premarital claim. If you had the practice or even your degree or some aspect of it before you got married, you're going to want to be able to separate the premarital from the postmarital value, and getting all those documents together as soon as possible. So I would say business and personal tax returns, credit cards, retirement statements. In the business, you can get receivables, trying to think with any kind of general ledger that you have, and really anything that you would be turning over to your accountant at the tax purposes, you want to have in advance, including the backup, not just the filed returns or the general ledger, but the receipts and any notes you have or any conversations, everything that you would have compiled for your accountant, compile for your attorney. This does not mean you're turning it all over, but you want your attorney and the evaluator or appraiser to have as much of this information as possible. Again, going back to what we were talking about a moment ago, if it's a joint or a individual. If it's joint, let your attorney guide you into what should or should not be turned over. If it's your own, turn over everything they're asking for. Do it as early as you can. Like I said, the hardest part to most divorces is gathering all the relevant information. Even if you didn't have a practice, the document requests in a divorce are very cumbersome, and you want to get on top of this as fast as you possibly can. You also need to make sure that you have non-disclosure and confidentiality agreements, not just with the evaluator, but possibly with your spouse and other attorneys. You want to make sure that none of the information that is exchanged can be released. You also obviously need to make sure that you're compliant with HIPAA and any kind of patient-doctor privilege protections. You don't want to trip over and harm any of your patients. That's obviously bad for the practice. It's bad for evaluation. And then in general, I also recommend that you do as much as you think necessary to let people know that you're in a divorce. You don't want to let the whole world know in your practice, because some people will view it negatively. They may worry about your ability to practice. They may worry about their stability of their jobs if they're your employees. So, judge on a need-to-know basis what you think is most important to keep the business running, but also to keep everybody kind of in the loop as much as possible. Now, a couple other issues when you're dealing with the appraisal of a practice. First, when you're talking to an attorney, ask about momentum. So the momentum theory, and this also is very significant if there's a premarital component to a practice or a professional license. So people generally think assets acquired during the marriage are marital assets. And there's an active and passive distinction that I can't go into in this because it's just too deep and outside the scope. But I do have other webinars that I'll try to link, depending on where we post this, about how assets are distributed. But so momentum basically says a business over time becomes more valuable, not just because the passage of time, but because of the original work is picking. It's sort of like when you roll a snowball off a mountain. You know, you might have the same amount of time as it goes down the hill, but it's going to gather more and more as it goes, and it's going to be larger. Now, some argue that the premarital momentum, for instance, is what led to the success that you currently have. And others will argue that it's the momentum gained during the marriage that had its most value, because when you start out in practice, you don't know as much. I generally feel the first is the more accurate. I believe the earlier sweat equity, sacrifices, and the long hours are usually what adds to the future, the later momentum. I don't disagree that the momentum during a marriage is valuable. I don't think it is as much. And the momentum issues for the marriage is, you know, the support of the other spouse, contributions to raising the children so that you could concentrate on your practice, and issues that we'll talk about in a minute when we come to alimony. But they all do allow for the increased value to a practice and allow for the practice to build. But it's my personal opinion, and I think the case law agrees with me more so, and that is that the earlier efforts, the earlier years, are what gain the most momentum and augment the value of the practice later in years to come. You also want to ask if there's any information that will assist in minimizing your spouse's claims. Now, there's often not a great deal, but other than like premarital, which I keep saying over and over again. But don't lose sight of the fact that the value of your practice is distributed based on the value of the marital relationship, which means all assets and debts are valued by equitable distribution, not by equal distribution. So if there is some reason to suggest that your spouse should not share in the equal value of the practice, at least during the marriage, then find out what those information or issues would be and make sure to get that information to your lawyer to minimize any claim that your spouse may have. Like I said, few times that is actually relevant, but don't overlook it. And there's a couple of things I didn't put into the slides, but you do need to understand, because one of the greatest weaknesses, in my opinion, about the current status of family laws, it's not realistic when it comes to valuation of a business. And I hate to say that to you when we're talking about evaluating your practice, but it is something you need to know. So it's not realistic because the law will not acknowledge that some businesses have no value. For instance, if you, and it's out of topic here, but it's just for your understanding, if you were a 1099 plumber, you just had a truck and you go out and you service your clients and you generate $100,000, $200,000 worth of revenue, that business realistically has no value because it's just based on you. If you stop working, you're not making any money. Nobody's going to buy that practice from you, assuming you're just going to keep working it. But in a divorce court, they're going to say there's revenue, there's a goodwill, there's a business list, there's receivables. It's got a value, and the spouse is entitled to a part of that value. So not only are you taking a business that has no value, no real value, no resale value, and assigning a value to it, then the person in this scenario has to find a way to buy the spouse's share of that business out, which they often have to do by taking a loan, which then they have to service the loan, which then decreases the revenue available because you have a new debt. So the business that didn't have a value is now, the value is even further reduced because the revenue is affected because you have to buy the practice out that has no value. And it's what the biggest problem I have with it. But that's the way the current law is. So you have to understand that and this could be the same for a physician. If you're a one-man shop that you have patients and a secretary, they're going to attribute a value to it, even though you're not necessarily going to be able to sell that. Now, a physician's practice probably has a greater marketability with a patient list and goodwill than the example I'm giving to you, but it's still important to understand that that's how it works. And also things to understand that the family court does not acknowledge is minority share discount. So if you're a limited partner in a practice and you couldn't really sell your share, it's not going to matter. You're not going to get an adjustment. Lack of marketability discount. If you, like an example I gave you where there's just no marketability, there's nobody who would be willing to buy this company at its full value, or your interest in the company not accounted for. It's almost like a multiple of the income and that's the simple way to evaluate a business, but it's going to have a value even if it's not realistic. And right now there's just no way around that. So you have to understand that. Now, the next topic that's likely to be significant, and I do have to, I guess, apologize because I'm doing this webinar with some preconceived ideas, and I think a lot of us will have that doctors have valuable practices, that they have a sizable income, and I know that's not always the case with everybody, and I know also the medical profession has changed significantly in the last 10, 20 years, and I'm sure in the next 10, it will change even more given the high costs of obtaining the degree and the difficulty that you may have in generating income to pay the loans, for instance. But it is how I operate. It is the nature of our client base. It's probably the nature of people who are watching this webinar, because if you didn't have the income or the practice, you wouldn't be concerned about its valuation and practices. But I just want to put it out there. I'm not trying to be offensive and just assume all doctors are making a lot of money. And that's not really what I'm saying, but they're going to have greater than nominal, we're above average, let's say, and that's kind of where we're operating. And that's important because we're going into support and alimony. So obviously there's always a lot of issues with support and alimony in any case, but especially if you have either a physician or, like I've been trying to intimate, a high income case. So first, don't just focus on your income, but focus on your spouse's income. And I talk about imputation of income because in a lot of cases like this, what we see, and I still see in a lot of just natural divorces, there's still a lot of traditional families in my community and my practice where you have one spouse that's working, one spouse that stays and takes care of the children, one spouse that handles the finances. And it's not always the same person, but there's often a division and not an equal contribution. So you might have a spouse who hasn't been working for many, many years. You may have young or grown children and that spouse is still not working. That does not mean the spouse cannot earn an income. So the first thing you need to realize is that there will be an imputation of income to the spouse. So how do you go about ascertaining that? First, you can look to past earnings and just basic on their educational levels, what you think a job that would be available to a spouse in that circumstance. But then you also may need an employability expert. And it's usually going to be separate from the expert you have for the appraisal of the business, because not usually can an employability expert evaluate a business. There are different sciences. And unfortunately, it's going to be another person to deal with, another person to get documents, and another person to pay. But it may be just as significant as the practice evaluator, because how much your spouse can earn now and in the future is going to greatly, significantly reduce his or her alimony. I also recommend that you seek to have the court, either through court-ordered support or just through negotiations, require that they search for jobs. And I say that because one of my greatest pet peeves in a divorce is you will get usually a temporary support set up in the beginning of a case, which can last a year or two, and sometimes even more, especially with the COVID quarantine issues and backlog that we have, and who knows what's going to happen as we lift that. And if the spouse's temporary support award, what's called Pendente Lite, is significant enough that that person's lifestyle needs are largely covered, that person's not going to do anything and have very little incentive to settle the case. I normally request, when I'm defending an application for temporary support, that the court require that every 3 months they submit to either us or to the court the efforts to find a job. And that you ask inside of that the failure to do so could be grounds to seek a modification of support, even a temporary support, because you don't want them to just be able to sit back for a year with no incentive to settle or be reasonable because they're having all their bills paid. And that's often what a temporary support is going to do. It's going to seek to preserve the status quo, we like to call it, which is never the status quo. Another pet peeve of mine, because when you separate physically or legally, your status quo is changing. You know, you have one house, it's going to be two. You may have one income that house, two houses. That's not status quo. Now, when you're talking about alimony, there's some practical and legal things you need to consider also. First is triggers for automatic review of support payments. Now, this is also one of those issues that kind of cuts both ways. Because if you're going to suggest, for instance, that a support should be reviewed every few years to see if the other spouse is earning more, they too could argue then to say, well, we should review the paying spouse's income every couple of years to see if he or she is making more. And what I usually say, while that logically makes sense, it's really not accurate, because alimony is supposed to be about preserving or providing a comparable lifestyle that you shared while you were married. So if you have a support that's based on that amount, let's say $100, let's say $100 is what provides you a comparable lifestyle, and that's what your alimony is, let's say, and then you go out and you start making another $100. Well, now you're making $200. You're living a better lifestyle than you had during the marriage. That's not the intention of alimony. Now, if the other spouse who's paying is making more money in the future, that too shouldn't necessarily matter, because the question is the lower earning spouse leading a comparable lifestyle? So you can make the argument that the review should only cut one direction. It's just not likely that if you're doing an agreement, which most of these cases will be, that you're going to get an agreement to have it only be a one-way review. And again, I don't know, you may hear that bang, so I apologize if it continues for a while and it's kind of annoying on my end. I can only imagine what it's like for the viewers. Next, you want to talk about cohabitation, language for that. The law does address it. I'm not a big fan of the way the law is currently written for cohabitation, and I'm doing this in 2021, sorry. So the current status of the law says if a person is found to be cohabitating, their alimony, his or her alimony, can either be modified or terminated. But it also says if the cohabitation should later end, they could seek to reinstate their alimony, his or her alimony. And that's frustrating, because cohabitation, to prove cohabitation, is a very difficult, long process. And if you're successful, the spouse receiving support can sit around and wait, take his or her chance in court. If they lose, then just tell the person to move out and then reinstate it all again. And you've gone through all this and you get it reinstated. It's horrible. Truthfully, I can't understand why they'd make a provision like that for a topic like cohabitation that would lead to that inequitable result. But it's currently the law. Now, you can have an agreement that says if my spouse is found to be cohabitating, alimony is ended. It doesn't need to be tracked by the same language in the statute that allows to reinstate it. You can change it, and that's why I think it's important that you address it. Now, when it comes to cohabitation, you're most likely going to need a private investigator. Make sure that you and your attorney, and presuming you have an attorney, understand the case law about personal tracking devices and how that can lead to domestic violence and temporary restraining orders. Very significant issue. Your private investigator should also be aware of this to make sure that he or she does not tread into murky waters with you in that issue. But if you're concerned about cohabitation in the future, it might even be cohabitation during your divorce when you're talking about alimony. You may need a private investigator to opine and to testify about whether or not there's cohabitation. And then lastly on this issue is, I always talk about double dipping when alimony and equitable distribution being separate. It's a very complicated issue, but generally the things I just say are very important to remember when it comes to setting alimony and discussing equitable distribution is just want to make sure to consider all the proper issues. So again, if there's premarital assets, you want to make sure that that's separated in equitable distribution. When you're talking about alimony, you want to look at, like, if there's going to be Social Security in the future, if there's going to be interest income from the asset division, if there's going to be pension payments from the asset division, that goes into how much income that person has. That reduces their need for alimony, or reduces the alimony need. So you want to look at all these and make sure that the factors from the assets, like interest and pensions, are being accounted for when you're setting alimony. Now moving on to other important support-based issues, child support in college. So child support, as most of you probably know, in New Jersey, it's done by a child support guideline. It basically says, take your income, the other spouse's income, some other costs like healthcare, recurring medical expenses, daycare, and you factor in an overnight credit, and you get a child support amount. Most cases, that is that simple. Although it's not really simple, I shouldn't say that. It's still a complex calculation, but the process is relatively simple. Now here, again, presuming a high income issue, the support guidelines in New Jersey go to a combined net of $187,000, which means both parents' income combined net of tax is $187,000 or lower. And again, I'm going on the assumption that that's not likely to be the case here, that the income is going to be above $187,000. Now, it doesn't have to be substantially above, but it could be $190,000. It still takes you off of the guidelines. And when you're out of the guidelines, you're supposed to do high income addition. Now, the high income addition is supposed to be based basically on the child's need. The problem is it's hard to ascertain that. Now, what the law says is that you're supposed to go through the custody factors and look at like educational needs and extracurricular activities and demands of the parenting schedules and other children and a whole slew of factors. In my experience, few courts ever do that, ever undertake that detailed analysis. More often than not, they either just grab at a number that seems reasonable, the parties agree to a number that seems reasonable. You could look at the specific needs of a child, like do they have special skills or educational needs? Do you have religion education that's likely to be costlier in the future? And I cite here the Strahan case where it says, the three pony rolls of how much can a child need. So, you may have a 3-year-old, and I'm making up numbers. Let's say you're making $10 million. That 3-year-old's needs are not so much more significant than a 3-year-old needs if you were making $100,000. So in an example like that, and this is the Strahan case where these issues came up with younger children, was how much extra does a child need? It's not just because you're making more that you should be paying more. It should be based on what is the need of the child or what are the children's needs in the future. Now, so you must consult. This is really the consultation part is about college, which we'll get to more in a second. But when it comes to selecting colleges, you need to be involved in the process. In the selection, in inspecting schools and visiting before you can, I was going to say before you can be responsible to pay for college. It's not really accurate. The law does say you're supposed to be involved in choice, but quite honestly, I've seen cases where the parent has not been involved, child gets registered for school, and the court still makes them pay because they don't want the child to suffer because of bad decisions that the parent may have made. So you want to make sure that you stay involved and don't just expect that because they chose it surreptitiously that you're going to be exempt from paying for it. You're probably still going to pay for it, which turns to the next side I have here, Black versus Black. It's about reunification counseling. This case talked about many issues, actually, and it's probably a good case to read. Just type Black versus Black, New Jersey reunification case, and you'll probably find it easily. But one of the important factors, it talks about whether or not you can be just a checkbook. So if you have a bad relationship or if you've been alienated or your child hates you, and hopefully none of this ever happens, but if you find yourself in the circumstance, the question is, should you really have to pay for college education? Given the cost of carrying and putting a child through college, if you have no relationship with that child, through no fault of your own, should you be responsible to pay for college? It's a complicated, difficult issue that many people are confronted with. So if you have that issue, you want to read this case, talk to your lawyer about it. Now, certain things, and again, a lot of my discussion is always premised on the belief that you're going to be doing this by a settlement and not by a court order, because I think it's 99.9% of divorces settle by an agreement. And the 0.1 that go, I think like 98% of those settle before the trial concludes. So it's like 0.01 that goes to complete trial. You're probably not going to be that one. So when you're doing these things, like you're saying about what you want to put into your agreement, for college contribution or support, you also want to write things like you may be putting in 529s. You may even have them at the time of the divorce or setting them up or any kind of tax deferred planning. You want to make sure that the agreement indicates that the account, if you're going to be setting up a 529 or you have a 529 that you're taking out, that when you do later contribute it, that it represents your share of the college contribution. I actually had a case come to me post-judgment. I didn't do the divorce, where the agreement spoke about the 529s that they'd put, and I think the dad had saved most of the money during the marriage, and the agreement had them contributing to college accounts after the divorce, but it was ambiguous as to whose contribution it was. So, for instance, my client was the one contributing to the 529s, and then mom was arguing that it's supposed to come off the top and then they share it, which made no sense because it was his sole contribution. Problem is, the agreement, again, we didn't do this, but the agreement that was drafted before our representation didn't define it clearly. So you want to make sure that you define that. If you're going to have pre-tax accounts or any kind of investment that you're putting prior to that or after your divorce, you want to make sure that it defines whose contribution is and who gets the credit for it. Next is you want to talk about what we call the Rutgers rule. And that says, or the question is whether or not you should be responsible to pay for college beyond what would be a local in-state school. So we say Rutgers because we're in Jersey. If your child could go to Rutgers for X amount of dollars, should you be responsible because they want to go to Boston U? Obviously there's, and I'm not saying these schools specifically, but obviously, in-state and out-of-state have significant price differences. It's not always based on the value of the education. It's often just based on the value of the fact that if you are in-state or out-of-state. And now some people, and I recommend you do this in your agreement, you indicate that you will only be paying for the in-state tuition and costs, regardless of where the child goes, and let them decide if it's that significant to go out of state, how they're going to do the balance of funding through loans and grants and scholarships. Now, the problem here is, I hate to say like in the old days, but when I was younger, they would allow children to take their own college loans and be responsible for the repayment of their own loans. Now, I'm pretty sure that's largely gone. And most loans, both private, institution, and government, are parent loans, or at least require parents to co-sign because they just wised up and realized that parents have a greater likelihood of being able to pay back than a graduating college student. So you have to write in, if you're electing the Rutgers rule, for instance, that the balance is going to be either something that the children are responsible for, or at least that you are not required to obtain any additional loans other than necessary to cover the Rutgers level. You also want to indicate that child support should be adjusted when the child goes to college. Now that will likely be considered a material and substantial change of circumstances, even if your agreement doesn't list it or indicate it, but you should put it anyway. Because the problem with college contribution and child support is that children go away to college and they incur new expenses, especially if they're living away at college. This is even more significant. If they're living away, you're paying room and board at college, but the custodial parent isn't necessarily being able to downsize their housing because they need to keep the space for the children to return on breaks and on summer. So you have a double dip issue where you're paying room and board and you're paying the custodial parent child support for room and board at home. So it generally leads to an adjustment downward of the current child support amount to offset the additional costs that you're paying for college. But it's not dollar for dollar. You're paying $3,000 for room and board in college. You're not getting a $3,000 adjustment to your child support. And that's largely because the expenses that child support covers for the custodial parent's residence don't change a great deal because one person moves out and goes to college. The rent or mortgage payments not change. The electric doesn't change a great deal. Insurance doesn't go down. You'll see a dip in things like controlled costs, like extracurricular and vacations, or variable costs like food, but it's not significant. So you still will be paying college contribution and child support, just usually a little bit lower. Another thing, you need to define whether your child's going to be living at home or going away. But at home, there's even more reason. These extra expenses, like are they going to need a car insurance, cell phone, extracurricular activities, prep courses, books. Don't just assume that college does or does not include these, especially if they're going to be either on campus or at home. Now, if they're at home, it's more likely they're going to need a car and a car insurance, but that's not guaranteed. There's Uber, there are buses. Those two may be factors or expenses you need to factor into it. And then if they're going to be on campus and they have a car, do they need a car? Should they have the car and insurance? Issues that you should contemplate and consider. And I'm not trying to talk just from a standpoint of, hey, let's cut your costs when your kid goes away to school, but, and I'm not trying to disencourage or dissuade people from paying these extra monies to help their kids get through school. I'm just giving you practical advice from a legal standpoint, so you're well informed when you go in there. And I guess for doctors watching this, the informed consent is kind of what I'm getting at. That I'm not telling you not to pay for their car or their insurance or private tuition out of state if you can and you want to and you value that. But from a legal standpoint, just understand you don't need to. And the tips and advice I'm giving you here, so you can exercise that choice should you want to. Now, other issues and professionals, aside from the business evaluation and employability, you should do estate planning. And this really is for all divorces. First thing I do, well, first or second thing I do, is I tell my divorce clients to draw up a new will. So whenever you file for a divorce, your will is revoked automatically by operation of law. But that doesn't mean that your spouse doesn't stand to inherit under your estate. It just means you have no will. You have no disposition decided. So you have to draw one up to make sure that your spouse doesn't receive or control your assets. You also want to consider who's going to handle your estate, which is the executor, who's going to handle your assets, trustee, and who's going to handle custody of your children, guardians. Now, children, a little easier, it normally will be the other parent, but that doesn't mean you can't draw up a plan that says that is not what you would like to happen. It may not control, but certainly if you have a reason to believe that the custodial parent or the other parent should not have custody of your children when you pass, you have every right to draft an estate plan that indicates that. If there's a custody issue, courts will look at it. Your intention as the natural parent would be viewed and considered. Doesn't mean it will be followed, but it's certainly going to be considered. You also want to consider the monies that you're leaving, whether or not you want the other spouse to be in charge of it, the trustee of the money you leave maybe for your children, or do you want to have somebody else control the finances? If you have insurance proceeds that are not part of your alimony agreement, that's a separate issue, but you may have life insurance, you may not want it to go to the other spouse, and you may. I'm not trying to encourage you not to. Generally, I believe that the person who is going to have custody of the children should have greatest control of the children's assets so that they can provide for the children's lives, but also not be burdened by having the children, because sometimes it's a third person that's getting custody of your children. But again, we're going kind of further out into estate planning issues beyond the scope of this webinar, but this is really just to tell physicians that you do need to consider these issues, that you're going to be leaving children and assets, and do you or do you not want the other natural parent to be the one who controls that? Other professionals, I always recommend you speak with an accountant. You want to understand tax consequences to your alimony payment, to your distribution of assets and debts. Now, and you'll hear things from lawyers say things like, well, there's no tax consequence to transfer of assets in a divorce, which is accurate. And you'll hear things like alimony is not tax deductible anymore, and that's accurate. But that doesn't mean that there aren't long-term tax consequences you need to consider, especially when it comes to equitable distribution of assets. Because while there is no tax consequence to the transfer of the asset, there are there can be capital gain issues years later when you try to sell the assets. And that's significant because quite often you'll be transferring one asset in lieu of another. One spouse may want to keep the home. You may want to keep the practice and, give your other spouse the house, or keep the practice and give cash, or cash account, investment account. You need to know and factor into your decision what are the tax consequences later when you sell the asset that you're keeping or giving away, just to make sure that you know that what you're getting is comparable or equal value. And you also want to look back at your tax returns and determine, are there any issues of underreporting? Is there a risk of future audits? And do you want to address how that's allocated in the future? Because, let's say, unfortunately, if there is underreporting and you're later audited, that would be a marital debt, and both spouses benefited from the underreporting or the lower tax payments, and they would share into that. They would share in that. So you do want to contemplate this, build in some language that says, if there are, and it's usually just related to tax views. I don't usually build in anything about adverse tax consequences like capital gains, but you can. I'm not saying that you shouldn't. But when I'm talking about future tax consequence, I'm usually talking about an audit and a liability, because it can be significant. And remember, we divorce attorneys can't give, and I say absolute tax advice, because we do give tax advice. I just gave you tax advice. But unless you're a tax attorney, we're not going to be as well versed as a CPA or a specific tax attorney. So you do want to speak to these professionals if you're going to have greater than average tax related issues, substantial assets, capital gains, or practice, professional practice. And lastly, and I say this to most of my clients also, I want to consider mental health experts. And this is for yourself. Divorces are taxing, they're emotional. You're taking probably the most important issues of your life, your children, your spouse, a practice that you may have spent a lifetime building, and it's being divided, being severed in some way. It can be taxing, and you don't want anything to impact your ability to run your practice or to conduct yourself through the divorce. You may just need a professional to speak with. Your children may need it. I highly recommend, and courts will always encourage children having therapy. It could be family therapy. It could be individual therapy. Usually you can talk to the therapist and have them decide what's going to be best for you and your children and your family. But I recommend doing it and following their instructions. And last, I know they call us counselors at law, but we're not therapists. And I say this not to sound like I want to turn away clients from seeking help, because what happens is, as you go through a divorce, you get to know your clients really well, and you do start to fill in the role as a therapist, because in many circumstances, we know what you're going through. We've seen hundreds and thousands of people, hundreds or thousands, not hundreds and thousands of people that have gone through it. And in some cases, we are capable of helping you understand and process it and move through it. And you'll get to know your attorney probably pretty well. But don't let that replace a professional mental health expert, because they're just issues that we can't understand and that we can't help you with. And you want to do everything you can to make sure the process goes well for you, your children, and even the other spouse. You're going to be, in many circumstances, in an ongoing relationship with him or her as you co-parent, as you divorce, as you have alimony obligations and modification agreements in the future. Your relationship is probably not necessarily going to end when your divorce ends. So be prepared to serve in that capacity in the future. That should be all of it, unless there's any questions that get posted, which, as I said, I will always address. You can email me. I'm not sure. My email's probably not here, but here's the domain, micklinlawgroup.com. And to email me is just brad@micklinlawgroup.com. You probably got emails whenever you register for a webinar, so you should have it. But if not, like I said, you can feel free to email me. Any questions you have there, I will do my best to address them if I can. And with that, I wish you good luck. I hope the process goes well for you, and I hope you stay safe.